One of them picked it up without asking. Another made a comment. All five were laughing. The briefcase was battered brown leather, sitting on the passenger seat of Imani Graves's car at 9:47 p.m. on a Tuesday in Memphis, Tennessee, 2 blocks from the federal courthouse she had just left. Imani sat in the back of a patrol vehicle and watched them laugh. She did not react. She had been waiting 14 months for this moment. And patience, real patience, the kind built from years of watching what happens to people who react, had become her most precise instrument. What the 5 officers standing on that street did not know, the briefcase they were laughing at contained a federal complaint filed that morning. It named all 5 of them by badge number 7 years earlier. This is where it started. The first time Imani Graves took a civil rights case, she was 32 years old and driving a car with a broken heat gauge she'd been meaning to fix for 3 months. She'd grown up in North Memphis, the daughter of a public defender who had practiced for 31 years in the same city, in the same overworked, underfunded, necessary way that public defenders practice everywhere, taking every case that came, preparing as though each one were the most important, driving home at 11 at night with a briefcase that never quite closed because it was always too full. Her father had retired 2 years before Imani started at the public interest firm. He'd given her his briefcase the morning she passed the bar, battered brown leather, brass clasps worn to the color of old pennies, a handle that had been re-stitched once in 1998 and held. She'd been carrying it ever since. The civil rights case was a wrongful arrest. A 23-year-old black man stopped outside a grocery store, accused of matching a description that, when Imani obtained the original police report, described a suspect 6 inches taller and 30 years older. The arresting officers had body camera footage that showed the encounter from beginning to end, including the moment one of them said the description close enough, and including the 37 minutes her client had spent in the back of a patrol vehicle, while they ran his name through every database available and found nothing. She filed in federal court. She prepared with the thoroughness her father had modeled, and that she had spent 7 years refining into something close to surgical precision. She won. Her father had told her, on her first day of law school, that the most important skill in this work was not argument. It was not research, though research mattered. It was not even writing, though writing was how you made everything else real. The most important skill was attention, the sustained, unglamorous, daily commitment to noticing what was in front of you and recording it accurately and keeping the record somewhere you could find it. He said that most injustice survived, not because it was invisible, but because the people who observed it didn't believe the observation was worth keeping. He said every piece of paper in his briefcase was a piece of paper someone had almost thrown away. He said she should never throw anything away. She hadn't. That case was followed by another. Then, another. By the time Imani had been at the firm 6 years, she had handled 41 civil rights cases in Memphis, 137, and developed a specific competency that her colleagues described as pattern recognition, and that she described, in the plainest terms, as paying attention. She paid attention to the same badge numbers appearing across unrelated complaints. She paid attention to which precincts generated which types of stops. She paid attention to the geography, the specific corridors, the 2-block stretches and the parking structures and the streets adjacent to courthouses and law firms and medical centers where professionals who happened to be black reported being stopped at rates that did not correspond to any traffic or crime data in those areas. She built spreadsheets. She built timelines. She filed public records requests for stop data and body camera logs and responded to every partial or delayed disclosure with a follow-up request. She did this the way her father had done his case preparation, not as a dramatic gesture, but as a daily obligation. Because the patterns were there, and patterns required documentation, and documentation was what made patterns into evidence. The pattern she had been documenting for 14 months, the one that had produced the complaint now sitting in the battered briefcase on the passenger seat of her car, involved a specific unit of 5 officers operating a 2-mile corridor between downtown Memphis's federal courthouse and the I-240 on-ramp. 6 black professionals, over 14 months, had been stopped in that corridor by members of that unit for infractions that either did not exist or were resolved without citation. No tickets. No arrests. 6 stops that produced nothing except 6 people who had to sit in their cars or on curbs while their evening was consumed by an encounter they had not invited and could not refuse. An attorney. A physician. A university administrator. A financial advisor. An engineer. A city council aide. All 6 had contacted Imani or her firm. All 6 had given statements. 3 had body camera footage of their encounters, obtained through records requests that had taken between 3 and 7 months to fulfill. She had filed the federal civil rights complaint that morning at 8:47 a.m. It named all 5 officers by badge number and full name, documented all 6 prior incidents with dates and GPS coordinates, alleged a pattern of racially discriminatory stops in violation of the 4th and 14th Amendments, and sought injunctive relief and damages. It was 22 pages of the most carefully assembled documentation Imani had produced in 7 years of practice. The clerk had processed the filing at 8:47 and confirmed receipt. The court had entered an unsealing order at 5 p.m. The complaint had been filed under temporary seal pending a judicial review of whether identifying information required protection, and the judge had determined it did not. At 5 p.m. on a Tuesday, the complaint became a public record in the United States District Court for the Western District of Tennessee. Imani had checked the docket on her phone at 5:12, standing in the courthouse corridor between a motion hearing and a client call. She had noted the unsealing. She had made no public announcement. She had finished her motion hearing, taken her client call, and left the courthouse at 9:47 p.m. with the briefcase her father had given her, and the quiet focus of someone who has completed a significant piece of work and is now simply going home. 2 blocks from the courthouse, the lights came on behind her. The stop was for a broken taillight. This was notable because the taillight in question was not broken, a fact Imani confirmed by looking in her rearview mirror at the moment of the stop and observing that both taillights were operational and had been operational for the 11 months since she'd last had the car serviced. A service record she kept in the glove box the way her father had kept his car records. Completely. Because you never knew when a record would matter. She said nothing about the taillight. She pulled over. She activated the recording function on her phone before the officer reached her window, pressing the button with the practiced ease of a woman who had advised 6 clients to do exactly this, and who had built 14 months of documented stops on precisely this kind of footage. She placed the phone face down in the cup holder, where it would capture audio without announcing itself. She provided her license and registration with the composed efficiency of someone who has done this before, who has, in fact, represented 6 other people who have done this before, in this corridor, with this unit, in the past 14 months. She recognized badge number 4471 on the first officer who approached her window. Her stomach did not tighten. Her breathing did not change. She had known, in the abstract way that a person knows a thing they have been carefully documenting, that this encounter was not unlikely. She recognized the second badge number. She sat with her hands visible on the steering wheel and let them run the standard checks that produced nothing as she had expected. as they had produced nothing across 6 prior stops she had documented in a 22-page federal complaint file that morning. But then something changed. It was the briefcase. The moment the first officer noticed it on the passenger seat, battered, overfull, the brass clasps catching the streetlight, something shifted in the group's energy. Not suspicion. Something looser than suspicion. He said something to the officer behind him that Imani could not fully hear, but whose tone she understood precisely. A third officer had moved to the passenger side of her car and was looking at the briefcase through the window with an expression that was trying to be assessment and landing as something else entirely. The fourth officer made a comment that produced laughter from the fifth. The laughter was the kind that exists in groups of people who have been doing the same thing together for long enough that they no longer need to perform inhibition. The laughter of people who believe in their bones that they are unobservable. They were not unobservable. 312 feet behind them, a rideshare driver named Deshaun Carter had pulled to the curb to drop off a passenger and found himself unable to pull away because the patrol vehicles had effectively blocked the lane. His app was running. His dash cam, a model that recorded audio as well as video and that auto uploaded footage to a cloud account in 30-second segments, was also running, had been running since he started his shift at 6 p.m., and had been capturing everything in its field of view with the patient indifference of a device that does not know what it is recording or why it matters. One officer opened the rear door of the patrol vehicle and asked Imani to step out. She stepped out. Another officer, the one with the badge number she had recognized first, picked up the briefcase from the passenger seat without asking. He held it in a way that was intended to be casual and registered as something practiced. He said something to his colleagues. The laughter this time was quieter, more deliberate, the particular sound of people performing confidence for each other. Imani stood on the sidewalk in the October night air, 2 blocks from the federal courthouse she had just left, and watched 5 officers laugh at her father's briefcase. She let it happen. All of it. Every second. She stood on the sidewalk in the October night air, 2 blocks from the federal courthouse she had just left, hands at her sides, expression composed, and she let 5 grown men in uniform laugh at a piece of luggage her father had carried for 31 years. She let them have the moment completely, without friction, without reaction, because she had learned, in 7 years of this work, that the evidence produced by people who believe they are unobserved is the most durable kind, and because Deshaun Carter's dashcam was still running 312 feet behind her, and because her phone was in the cup holder capturing audio, and because 22 pages of documentation bearing all 5 of their badge numbers had been a public record for 4 hours and 47 minutes. Then she spoke 11 words, delivered in the even tone of a woman who is stating a fact she has been waiting a long time to state, that the briefcase contained a federal civil rights complaint filed that morning, and that the complaint named all 5 of them. She said it once. She did not raise her voice. She did not repeat it. The officer holding the briefcase stopped smiling, not gradually, completely, in the single frame between one expression and the next, the way a person's face changes when the world has reclassified itself and their expression hasn't caught up yet. The others registered the change in him before they processed what she had said. The way people in groups read the person closest to information before they read the information itself. 1 second of watching his face. Then the processing began. The others registered the change in him before they registered what she had said, the way groups of people read the person closest to information before they processed the information itself. Then they processed it. One of them, the fourth, the one who had made the comment that drew the laughter, reached for his phone. He pulled up the PACER federal court filing system, the public records database every law enforcement officer in this district knew how to access, and he typed in what she'd said. The complaint had been unsealed at 5 p.m. It was there, all 22 pages. His badge number appeared on page 4, page 9, page 14, and page 20. He went very still. Imani watched all 5 of them read. She did not speak again. She did not need to. The streetlight was steady. Deshaun Carter's dashcam was still running, had been running through all of it, and at 9:59 p.m. his cloud account received its latest 30-second upload. The one that included the moment the 4th officer found the filing. The one that included his expression. The ones that included all 5 of them standing on a Memphis street in silence at the conclusion of a stop for a taillight. That was not broken. She drove home. She made tea. She sat at the kitchen table where she had grown up doing homework while her father prepared cases at the other end, and she opened her laptop, and she worked for another hour on the motion she had been drafting for a separate case, and then she went to sleep. At 11:18 p.m., Deshaun Carter, who had arrived home from his shift and pulled up his dashcam footage with the routine curiosity of a man who checks his recordings when something unusual has happened on his shift, posted the video to his social media accounts with a caption that contained 5 words: "I don't think she's wrong." By 1 a.m., the video had been viewed 400,000 times. By 2 a.m., the federal complaint, now a public document, available to anyone who knew the case number, and findable by anyone who searched any of the 5 badge numbers in the caption thread where users had posted them, had been downloaded 11,000 times. Legal Twitter, as it was still sometimes called, had spent 3 hours dissecting the 22 pages with the precision of a community that knows how to read a federal pleading and understood exactly what they were looking at. Law professors, former DOJ attorneys, civil rights litigators from a dozen cities who recognized the pattern documentation, the geographic specificity, the methodical evidentiary structure of a complaint built not in a week, but over more than a year. Several of them said so publicly. Several of them tagged the complaint in threads that reached audiences who had never read a federal court filing in their lives and were reading this one by 3 a.m. The first resignation letter arrived in the chief's inbox at 3:14 a.m. No explanation. Just the letter, signed, effective immediately. The second arrived at 4:41. The third and fourth arrived within 11 minutes of each other at 5:23 and 5:34. The fifth, the one belonging to the officer who had held the briefcase, badge number 4471, whose face was the clearest in Deshaun Carter's dashcam footage and whose name appeared most frequently in the complaint's documented incidents, arrived at 6:44 a.m. 9 minutes before the start of the shift he would otherwise have reported for, in a building 2 blocks from the federal courthouse, where Imani Graves had filed 22 pages of documentation the previous morning. 5 letters. 1 night. No coordination between them, each officer acting independently, each one reaching the same conclusion through whatever calculus a person works through at 4 a.m. when they have watched themselves on a screen with 500,000 witnesses and found their name in a public federal document and understood. With the cold specificity of a fact rather than a fear, what the morning was going to bring. The chief called a press conference at 10 a.m. He spoke for 7 minutes. He used the word accountability 4 times, the phrase department values 3 times, and Imani Graves' name not at all. After the press conference, a reporter from the local paper found Imani outside the courthouse. She had a hearing at 11 and asked for comment. She said the legal process would proceed as appropriate and that she had no further statement at this time. The reporter asked if she had been surprised by the resignations. She paused for a moment, the way she paused when she was being careful with a word. She said no. She said she had not been surprised. The federal civil rights case proceeded. The city entered early settlement negotiations. The terms, finalized 5 months after the stop, included a consent decree requiring the installation of functioning independent dashcams in all patrol vehicles in the corridor, mandatory bias training for the entire unit that had operated in the corridor during the 14-month period, and a $1.4 million damages payment distributed among the 6 individuals named in the original complaint. The settlement also included a provision Imani had insisted on, and the city had initially resisted: a formal review of all stop data in the corridor for the preceding 3 years, conducted by an independent auditor, with results made public. The audit found 41 additional stops, meeting the pattern's profile. Imani filed supplemental claims within 60 days. The 5 former officers did not contest the settlement. 3 hired attorneys and reached separate civil agreements. 2 did not. All 5 were effectively uninsurable for law enforcement positions in Tennessee within 18 months of their resignations, a consequence that produced no announcement, no press conference, no moment of public reckoning, just an absence. The specific absence of 5 names from the rosters of every department that reviewed applications during that period and found, in the public record, 22 pages of documented conduct they preferred not to inherit. Imani's father called her the morning after the video went viral. He had seen it on a neighbor's phone. He had watched it in full, all 4 minutes and 32 seconds. He asked her if she was all right. She said she was. He asked if she had known it would happen this way. She said she hadn't known specifically. She had known that the complaint would become public, and that the night it was filed was the night she was most likely to be stopped in that corridor, because patterns don't pause, and she had believed that if she was stopped with the complaint on her person, the encounter would be documented by her own phone. She had been recording from the moment the lights came on, and that documentation would matter. She said she had not anticipated Deshaun Carter. Her father was quiet for a moment. Then he said that the best cases always had something you hadn't anticipated. He said it was what kept the work honest. He said he was proud of her. She said she knew. He said he was going to say it anyway. After she hung up, she looked at the briefcase on the table beside her coffee. Battered brown leather. Brass clasps the color of old pennies. A handle restitched once in 1998 and holding. She had carried it for 7 years, and her father had carried it for 31 before that, and in those combined 38 years it had held case files and motion drafts and client statements and evidence requests and every form of documentation that is what the law looks like when it is being practiced by someone who believes in what it is supposed to do. She opened it. She took out the file she needed for the 11 o'clock hearing. She closed it. She picked it up. She walked toward the courthouse in the October morning light, briefcase in hand, the same as every morning, the same as she intended every morning to continue being, for as long as there was work that needed doing. There was always work that needed doing.